Alien sibling. Alien sibling. Oh. Oh. Wait, how do you...
What the hell happened? My God. Me?
Sticking the butt. Tell him to get on.
Do you see me?
Yeah.
You're not on mute. Mute. Okay. Get there.
The phone number ending in 81, can you please identify yourself?
Gregory Hay. Can you hear me?
Yes, I can hear you.
Gregory Hay.
Are you appearing at 10 o'clock?
No. Yes, 10 o'clock. That's correct.
Okay, thank you. Could I get you to mute yourself, please, until the judge calls your case?
Yes, I will try. I'm on. I'll do that.
Yeah, thank you.
Look what it's doing.
Ms. Thompson, are you having some issues with your WebEx? Ms. White,
Yes.
are we expecting anyone else for this hearing?
I do not believe so. So thank you. Although I don't know, it says key rate Brown. I don't know. Hopefully, I don't know if that's Governor Brown or just somebody else. Is there a person named Brown in online? Hmm. Well, then anyway, I think it's only me then. Sorry.
Okay, thank you.
Oh, okay. I see. So everybody's appearing remotely. Okay. Let's have a look. Okay, so we are on the record in Bong versus Department of Justice, and that is 23 CV 45434. This is the time set for a hearing on motions filed by plaintiff. I'm just looking to see, there's an awful lot of filings in here. I don't want to miss anything. Those motions being compel production and so there's a motion for sanctions as well as, oh man, a motion to strike. And there's also an objection to subpoenas. So I guess I need to know what it is that the parties need resolved today, or what we need to have a hearing to resolve.
Your Honor, this is
There
Tracy
seem to be
Wade, if I may
several things.
speak.
Yeah.
Yes, hello, Your Honor, I'm with the Department of Justice.
Uh-huh.
It was my opinion that when we were appearing today on the motion to compel, and perhaps the
Yeah.
motion to strike, perhaps the motion for sanctions, which is related to that. I'm not sure about a motion to strike. So,
Okay.
yeah, so I'm not sure about what that even is.
All right. But the
Oh, wait,
motion to
there was a
compel.
motion. I'm sorry, Your Honor.
Okay. So we definitely have a motion to compel. And
Right, if I,
okay, Ms.
Your
Bong.
Honor, I believe there was a motion, possibly a motion to strike that had to do with my various affirmative defenses, I'm thinking, but I didn't know that that was set
Yes.
for a hearing. Although I think
Well,
we responded, so.
I'm sorry, did you say you have not responded?
I believe we did respond, Your Honor, but I
Yeah,
can
yeah, I
check to
see
be
that.
sure.
Okay. Yeah, it looks like you responded. It looks like the filing is 12224.
Oh, yeah, so
That's
it
what
looks
it
like we
says.
did. I didn't think this was for this, but if we can get them all done at once, that's okay too.
Well, yeah, that's kind of the question. Okay, so Ms. Bong, is that what you also think we are doing today? Is the motion
Your Honor,
for? Oh, go ahead.
sorry. Yeah, so the hearings for today was basically for the motion to
I'm sorry, I didn't
compel.
hear you.
I think Ms. White and I have already the hearing for today was pretty much for the motion to compel. I think Ms. White and I have pretty much fully briefed the motion to strike, and in my opinion, I don't think we need to argue that. But if Your Honor
Okay,
would like to hear arguments, I'm okay with that as well. But the main issue would be the motion to compel production, I think.
sure. Okay, well, let's start with that then. And give me just a second here. Okay. All right. Haven't printed that up yet, but I know where it is. Okay, so yeah, let's go ahead with that motion to compel. And if I mean, we don't have unlimited time, but depending on what we get to next. Yeah. So, Ms. Bong, if you want to start off with your argument on the or your is there going to be a testimony offered factually, or is this a legal argument?
I believe it's a legal argument. Other than Miss White, do we have any dispute on the deadlines and service dates? And I don't think we have any dispute on that. So I don't think we need to testify to those facts, other than just legal arguments. But I'll be happy to be on camera if you need me to.
Well, let's see. I'm sorry, and I'm sorry, I've forgotten your name. Ms. Is it?
Bong.
No, I'm sorry. That Ms. White. Okay, sorry.
Yes, Your Honor. I agree with the plaintiff that on this motion to compel, it's just the application of the law. There's no dispute about what
Okay.
happened.
All right. So, Ms. Bong, we'll go ahead and let you lead off and give your pitch, so to speak, and go ahead on.
So I serve the respondents with not a total of 9 requests for production. It's pretty much communications between the Department of Justice and the Department of Administrative Services, between the Oregon Health Authority, potentially Rachel Banks, who is the public health director, who is the one of the defendants in my federal lawsuit that the DOJ is defending in both her official and personal capacity, I believe. Same with the communications between the DOJ and former Governor Kate Brown with regards to providing defense for her in her personal capacity. I've also requested documents from the DOJ with the Oregon Health Authority, as well as I believe the governor's office, once again with regards to providing legal defense for Kate Brown and Rachel Banks in their personal capacity. That is my main goal of my request for production. And my contention is that some of these documents may reveal that the respondents have admitted that they do not have the authority to defend Kate Brown and Rachel Banks as individuals in their personal capacity outside of the Oregon Tort Claims Act. Ms. White has raised some objections, which I contend that she has waived because she has missed the 30-day deadline to raise objections, according to ORCP 43. And 46 would be my motion to compel. ORCP 46 is my motion to compel.
46. Gotcha. So it's a two, well, is it a two-part argument that they have missed their deadline, so they don't get to object, and also, even if they were able to object, the objection shouldn't be, shouldn't be granted because your requests are appropriate?
Correct.
Is that okay? So I've summarized what your point is well enough. Just want to make sure that that was what you were arguing.
Yes, I'm sorry. I'm not a professor. I'm not a lawyer, so I'm trying to
And
make
that's
it
why
as
I'm
succinct
and that's
as
why I'm
possible.
asking you to make sure that I have understood you correctly, that that was what you were arguing, is
Yes.
that they are barred from objecting, and even if they are not barred from objecting, the objection should be overruled because it's not reasonable, and that what you are asking for is reasonable.
Correct.
Okay, I understand that. And so, Ms. White.
Yeah, yes, Your Honor. A couple of things. I believe that it is my impression that the motion to compel is based solely on the lateness of our response. And so I did not plan to respond to anything about defending our objection. So if that's what we're supposed to do, I guess I would kind of be a little bit winging it, but I could do it. But I don't think that's what the motion to compel says. And so addressing what the actual motion to compel says, it's saying that because we responded a few days late, our response is waived. And the answer to that simply is, Your Honor, is that my secretary inadvertently calculated the wrong due date. And so I responded accordingly. And under those circumstances, it wasn't like a deliberate or even a forgotten due date. It was just simply a clerical error that, in fact, the attorneys did not make. And so, as set forth in our response, a motion to compel is a decision that is within the authority of the judge to yourself, of course, to grant or deny. And in this case, with it being a clerical error, the court should not grant the motion. There's a few other arguments that are set forth there, but besides the main one, which is just that it was excusable error, and also that even a late response doesn't waive the objections, we believe the key thing is it's excusable error, but also, Your Honor, this case is purely a legal argument. It has to do with whether the state DOJ has the authority to represent people, current or former state employees in their individual capacity as opposed to just their official capacity. And that's just a legal issue. The documents can't prove that. If there were any admissions made, that's irrelevant because this is a legal issue. You can't just admit away a legal issue. And so these documents just don't matter and shouldn't even be gotten or sought. And therefore, the motion to compel is irrelevant because the request itself is, if not inappropriate, because I'm not saying that Ms. Bong was trying to do something inappropriate, but they aren't within the scope of discovery. And so for that reason, the motion to compel and its related thing, the motion for sanction, should both be denied, and this discovery shouldn't proceed.
Stand by. Okay, so Ms. Bong, I guess the question I would have then, in light of Ms. White's argument, the documents that you're seeking to get from the state, is it that you believe that what discovery you might receive may show that the state are you seeking evidence that the state attempted to represent these people in their personal capacity, or is it that you think the state believes it should not do so?
There would be both, but I contend that they don't actually attempt. They actually did, because the state has appeared in my federal case, defending both Kate Brown and Rachel Banks in their personal capacity. So in terms of the documents I've requested, that may reveal that they will be attempting to represent them, but in that matter, they have already appeared to represent them in the federal case. With
So
regard,
you're saying there wouldn't be any dispute as to whether they are actually representing these two individuals?
unless Ms. White says otherwise, but to my understanding, that is what the state is doing currently in the federal case, is that the state has appeared for Brown and Banks in the federal case in their personal capacity.
And that's absolutely
Okay.
true, Your Honor. We have in this other case, and we routinely do. And so this is just a legal issue. I do not believe by admissions you can admit like away a legal
Yeah.
a legal issue, no matter what you said. And so
Well,
these
no,
documents just
what
aren't
I'm looking at
necessary.
is, it sounds like there's no factual dispute here. You're not saying we never represented them, or what Ms. Bong is alleging is untrue. Is that correct? That
Largely, Your Honor. I mean, we do
Oh.
think it's untrue as to the legal statements, of course. But
No,
as
that's
to
different.
totally, yeah, sorry, I'm interrupting you, and it's hard for internet here.
No, it's all right. You weren't interrupting me. So it's that there's not so much a factual dispute as there is a argument over whether what the state has done and admittedly done is legal or not, or subject to what Ms. Bong is suing over.
That's the underlying nature of the case, Your Honor, which if you allow us, I would like us to go ahead and set like a legal briefing on those issues. But here is the motion to compel, which we say is, again, it was an excusable error, but also seeking documents that are irrelevant to this dispute.
Okay. And Ms. Bong, are you aware of a factual dispute between yourself and the state?
With
Something that they
regards,
would deny is true?
um, I don't think so, unless Ms. White has
Okay.
raised some issue other than legal
I didn't
argument.
hear one.
But it doesn't seem like there is a dispute between us with regard to the facts.
Okay. That's what Ms. White was saying, is it doesn't sound like you're alleging facts that they would deny with testimony to say, well, that did not happen. Their dispute with you is over whether the legal aspect of that is, I guess I would say, right or wrong, or whether you have a case. So it doesn't sound like you would need discovery on this, because they're willing to stipulate or admit to anything I'm hearing you allege as a fact.
Okay, is that correct? Can we say that, Ms. White? Can we stipulate that there is no factual dispute on that?
I think we can largely, Ms. Bong. I'm just trying to quickly pull up my
Yeah. She's going
answer
to look
here.
back through your petition, I'm sure.
Right,
to make sure.
and I would have to, Your Honor, unless you want to just pause a little moment here. In general, it's true. We represent defendants in their individual capacity all the time. I don't remember, and I can look if she said anything that was like a little bit off with a date or something like that, But
Okay.
really, the legal issue is undisputed. Or
Okay.
the idea that we represent
The
people.
factual
Right.
representations are undisputed. It's
Right,
the
and it
legal
would-
assertions
yes.
that are in dispute.
Right, and there's, I think, looking over here, there's some, dates that might be wrong from the federal case and some stuff, but really, that's not relevant to the underlying issue, which is, as a legal matter, can the state do as it has long done, represent individuals? Of course, individuals who it has to, related to their, employment, of course, with the state.
Okay.
That would be my factual allegation, that they acted out of scope of their statutory authority, both Brown and Banks. And my question to the court is, if and how the DOJ can defend them in their personal capacities if these current or former officials acted out of scope.
But if I could clarify,
Okay,
Your Honor, that's still a legal issue because, for example, and
It
Ms.
does
Bond,
sound like
correct me, there's no talk about like, oh, we're representing a former employee for some random car accident they have. It's still things that they did, when they were employed. So it just has to do with what is the scope, I guess. But even that's a legal issue, I contend.
And I presume, Ms. Bong, that you're not alleging that the state is defending them in something the state would deny defending them in. Is that correct? Like, you're not saying they defended the individuals in like a car accident, and the state would say, we did not defend them in that. It sounds like you and the state both agree as to what the defense or what the actions of DOJ has been. Your dispute is that should not have been done that way because that is outside the scope of their employment. DOJ disagrees with you.
Yes,
that
I
fair?
believe so. Yes.
Okay. And Ms. White, does that sound correct to you as well? That really there's an argument over whether the whether what is being defended is beyond the scope of their employment or not, but there's not a dispute as to what it actually is.
I think that's right. And I'm just looking over my answer that I previously filed. And, there's some dispute about, there's some denial of, statements that I think are really statements of law or maybe some dates and stuff. But I really think the issue is strictly on, can DOJ defend somebody? Because often, and I don't know if this happens as much in state court, Your Honor, and I think both me and Bong will agree, often people are sued, like you might sue a judge or whatever, somebody, and
Yeah.
say they did this both in their official and in their individual capacity, for example.
Mhm.
The head of Oregon Health Authority or something like that. And we routinely do that, especially in regard to Section 1983 claims that are often, but not always, brought in federal court that have to do with, violations of various constitutional amendments and such. And
Okay.
so that's the legal issue, and I think it's strictly a legal issue, and we should brief this as far as instead of having an actual trial, is my proposal.
Okay.
But that's beyond the scope of this motion. I absolutely.
Yes, it is. And so
I'm sorry.
given that both parties appear to agree that there is not a true factual dispute, that anything that Ms. Bong is alleging as a fact is effectively admitted by the state or near on so, there might be minor discrepancies, which maybe there could be an argument over later, but don't sound like they would be determinative in any type of decision, like whether it was the 3rd of October or the 4th of October. Is unlikely to make much difference in terms of what a court would decide either in the plaintiff's or defendant's favor. I'm not hearing a reason to compel any further discovery, given that there is no factual dispute that testimony or physical evidence would illuminate for a decision maker. And I want to make sure that both parties think that that's a fair assessment of what they are each saying.
I think that's right, Your Honor.
Okay. And Ms. Bong, is that your understanding as well?
Well, I feel like because Rule 36 says that all forms of discovery parties may inquire regarding any matter not privileged that is relevant to the claim. I feel like that might be some documents or information that might come up that would help with my claims. But
So it sounds like you're kind of asking for a fishing expedition, which I don't think I could grant. But if there is something that you can point to that says they are denying this fact, or I believe they would deny this fact, or something like that, that discovery would illuminate and maybe make more likely or not, I don't necessarily have a problem with that. The issue might be running into lawyer-client privilege, but I'm not hearing you say what it is that you would get, that you would be reasonably expecting to get from this, other than with random hope there may be something that helps you. But really, it sounds like they are agreeing with the facts as you allege them.
it does appear to be so. However, the higher courts have allowed the discovery questions to be broad and fishing to
Sure.
be allowed because I really don't know what they have or what could be revealed in disclosure. And that's why I filed my request for production in the way I did. And, because I really
Mhm.
don't know what will come up.
Yeah. And I don't have to hand immediately what the limitations on a discovery request would be here, but I'm just really not hearing how that would. Am having trouble picturing how it is that any discovery of any fact would assist your case, because you've alleged facts. The state says yeah, and also you're making a legal charge. They shouldn't be doing this thing, and they're not saying they aren't doing the thing. So I'm not sure what discovery would get you. I mean, I'm just really having a struggle with how you could be advantaged at all by any discovery. I'm really having trouble picturing that. And you were citing to ORCP 36, is that what you're saying?
Yes.
Okay, give me a second.
Oral CP 36B1.
B1. All right. Let me have a look at that to. Yeah, see, and it's that for all forms of discovery, parties may inquire regarding any matter not privileged that is relevant to the claim or defense. Given that they're stipulating to all the facts, I'm not sure how any fact would be relevant to the claim or defense, because they're not saying that what you're claiming is untrue. And so further proof that you're right isn't relevant, because they're admitting they've stipulated basically to the facts.
Okay.
I mean, not maybe officially. And if there was any type of dispute of fact, then we would be looking at a discovery question. It's like, well, okay, now what do I need in order to establish that fact that they are at variance with me on is more likely mine than theirs? But I'm just not seeing how there is a possible relevant item, given that it doesn't sound like facts are in dispute. Does that make sense?
It does make sense, Your Honor. So in
Okay,
this
okay.
case, then if there are no factual disputes, then
Right.
I'm thinking that we should move for potentially judgment on the pleadings or summary judgment, since there's
Well, and that was
nothing
actually
more.
what Ms. White was getting to, I believe. She said, well, this is going to be a legal argument. So effectively, if everybody has agreed to the facts, what you would be doing essentially is, instead of a trial where evidence is submitted and you'd have like a trial looking thing, you almost would be going forward to what would be like closing arguments and saying, here's why the facts that we all agree on get me to where I am, and the defense would say, here's why the facts as they are get us to where we are, and the court should decide this legal question from this briefing. Now, the briefing could be in writing or verbally, or however you wanted to do it. But as far as the discovery, I'm really not I'm not seeing how the motion to compel discovery complies with Rule 36's requirement that it be relevant, given that there are no relevant facts that would be revealed, given that everybody's agreed to the facts. And I am willing to be argued with as far as whether there are actually facts that people are disputing. And Ms. White, is there something out there that would be that you're saying that isn't so, that fact is untrue?
I don't think so, not for the underlying question, which is it okay for the DOJ to represent people in their individual capacity of things that I know, and I know the dispute has to do with in the course of, but even if we just say that things that they did while they were employed, by the state, I think that's the issue, is just like, how do these statutes apply and that sort of thing. And so, and which might be a kind of interesting issue, but I think we should just call it a trial on the briefs or summary judgment or something like that.
Okay. Ms. Bong, is that okay?
I think that sounds fair.
Okay.
Then I think we can move for summary judgment if there are no factual or serious factual issues to the case.
Okay. So then the question becomes, how do we want to do that? Do we want and I'll hear from each of you as far as how you do it. And actually, you don't necessarily have to both do it the same way. Are you each wanting to submit a written memorandum or something like that in closing or something like that to get the court to make a decision based on your written filing or all of your written filings? Or do we want to have a hearing where the parties would also have oral argument in addition to whatever else they might file? Or how do you want to do it? And I don't know that we need to call it any particular thing other than, we could even call it trial if you like, or hearing on motion. Because since we all know basically what we'd be doing, how do you want to do it? Do you want to have a hearing where you can present oral argument in your favor, or do you want to do this exclusively in writing? And I will say, if either of you wants to have oral argument, I will set a hearing for oral argument, and then you can make it if you wish. How would you like to do it?
I have no objections to whatever Miss White wants to do.
Okay.
Written's fine, oral's fine.
Written's
Both
fine,
written and
oral's fine
oral
too.
would be fine as well.
All right. Ms. White, how would you like to do it?
Well, Your Honor, I don't know about you, but I think much better on paper. And I probably sound smarter on paper too. So what I would propose, and I don't know, I would suggest we'd skip summary judgment and just call it trial on the briefing or
Yep.
whatever. Although,
That would be my thought. We'd be going right
yeah.
to the final decision. Yeah.
Right. And what I think, and I've had this in another case. I think it was a state court case up in Multnomah County. Is that we did something like that, although we did actually show up. But the idea was we would do that, and then kind of if the judge wanted, or we kind of could do oral argument also, maybe by video like this. I think that's what we did, although I may be blending cases. But I would propose we write our briefs, maybe the way that we each get to respond to the other guys, and then
Yep.
and then see if we if it would help you or something to have oral argument. I don't know about Ms. Bong, but I can't really say anything more than what I've said in writing in general. But we can see how it is when the time comes.
Okay. So let's do this. Ms. Bong, let's have you submit your argument. You could call it closing argument for trial or however you want to title it. But your next filing would be an argument in your favor so that the court would to argue your case. And then if we could have that from you, I don't want to set this out very far. Would 30 days be okay?
If it's possible, Your Honor, I have a serious surgery that I'm undergoing next week. So if it would be
Oh.
possible for me to get more time on that to recover, I'd appreciate it.
How long do you expect to be in recovery?
Could we do 2 months out before the briefing is due?
The deadline?
Yeah.
Ms. White, that'd be okay? 60
Oh, that's
days?
fine with me, because I was going to tell you, Your Honor, that I have a trial in fact, exactly 1 month from today.
Okay. So, yes, Ms. Bong, so the deadline to have your closing argument or whatever you want to call it submitted would be 60 days from today. That'd be about May 7th. So if you could have your that argument submitted May 7th, then the state will have, would 2 weeks be enough to respond, or do you want a little bit more?
Let me just look at my calendar here. We have had so many
Sure.
trials lately.
That's fine.
May 7th, I theoretically have a trial, but I'm not even sure it's going to really happen. But anyway, May 7th would be the 21st, and that should probably be okay. So let's
Okay.
call it, what is that, May 21?
Yes. And so, yes, so the deadline from the state to respond with its closing would be May 21st. And then Ms. Bong, because you're the plaintiff, I would give you last say, if you wanted to respond to theirs, please have any response to their argument in by the 4th of June. So we'll give you 2 weeks on that.
Okay.
But any argument you're going to make that you're going to make up front, please put in your first closing. Don't wait to respond.
All right.
Everything you need to put it all in there at first. And so at that point, once the court has all 2 or 3 of these filings, because Ms. Bong's reply to yours is not required, but once I have everything and June 4th has gone by, I will look through them, and if I have any questions, we will contact you and set a hearing. If I don't have any questions, if I think I understand what everybody's argument is and can make a decision based on the stipulated facts and your arguments, then the court would just issue a judgment at that time.
I have no objections.
That sounds good. And I was thinking, Your Honor, that it might be that Miss Bong and I can actually like write up some stipulated facts, just
That would maybe be wise, so that way that could be submitted by either one or both parties saying, here's what we've stipulated to, since everybody's going to get a copy of it and there's not going to be any secrets. So yes, that might be
good.
ideal. And so what I will say is, although the court is then permitted 60 days to make its decision, I'm not going to take that long. Once I have everything, I would expect to have it done pretty shortly, but I will promise it by, oh dear. I'll have it done by July 12th, even though I might have it till August. I'll have it done by mid-July. If you haven't heard from us by then, obviously you can call and say, hey, did the judge finish the thing? And they'll chase it down with me.
Okay. And Miss Bong, when did you say your surgery was? Just to see if we can talk before then to get our stipulated facts.
I'm going in early next week, so
That's pretty soon.
yeah, it's pretty soon. I think I probably won't be able to be. I won't be able
No,
to.
I wouldn't think so. Well, maybe
Yeah.
after a month or so, I could write up something, and then maybe when you feel a little bit better, even if you don't feel up to writing briefs, maybe you can take a look at it.
Okay, yeah, I have no objections. Objections to that.
Yeah, okay. So that's what I'm gonna do. I'm gonna Tracy to write up, and I might not even write them up until my my trial is done, but we will see.
Very well. So in the event that there is a hang up on the stipulated, if you find that you can't stipulate to everything that the parties are asking for, by all means, request a hearing. We'll get you right back in and we'll hash out what we need to. But at this point, it sounds like things are likely to move smoothly on their own between the two of you.
I think so. And what do you want us to call these things? Are we calling it what are we calling it?
Why don't you go ahead and call them closing arguments?
Okay.
That seems reasonable, given that it's like a sort of trial, because it's just a stipulated facts trial.
Okay, that sounds good.
Okay.
And yeah, so that sounds good. It makes this move along. Thanks.
Yes, and Ms. Bong, if you want to clarify if you were to respond to the closing arguments of the defense, if you wanted to call it response to closing arguments for the thing that would be due in June, that would be fine. Or you can just call it further closing arguments or something like that. I'm not going to be too fussy.
Thank you,
All
Your
right.
Honor.
Thank you, ma'am.
And Your Honor,
Thank you,
if you'll just-
everybody. And
Oh yes,
Oh,
Your Honor,
yeah,
if
go
you can stay with us here for a minute.
Sure.
I'm sorry. Which is that first of all, I assume that the motion to compel and sanctions is denied.
Yes, I'm sorry, I should have said that. Yeah, the motion to compel is denied as being unnecessary, or it's not really moot, but it's unnecessary in that since the facts are all going to be stipulated, there is no reason to have discovery, further discovery. So,
And then the motion
yes,
for
I'll deny the
sanctions?
motion for sanctions and discovery, to compel discovery, because it's unnecessary. And
Do you want me to write those up, or do you normally do that?
that doesn't sound like a standard form we have. If you would provide those, yeah, and make sure the other side sees them, I'll sign
Right.
those.
Okay, I will do that. And then we
And-
did have this pending motion to strike. I don't know if we need to
Well,
worry about that
And
anymore.
I believe the motion to strike really is not different from the argument that I would expect to see in closing, at least in part. Ms. Bong, is that fair to say?
Well, the state has brought up certain defenses, which I've moved to strike because, well, one, they were not pleaded with particularity or specificity, and some of them were combined, which were against, I believe that's ORCP 21. So I don't feel like I should have to argue those defenses, because they were just one line defenses, and I'm not sure what exactly the state's arguments are with just one line, and therefore I moved to strike those.
Okay. That might require a separate hearing because it's definitely not regarding facts. It's more a question of, how about this? If the two of you are going to be discussing what facts you could stipulate to, would it make sense to have you discuss what to do with the motion to strike as well? We can set a brief hearing on the motion to strike also, to check up on you. I'm just not sure that needs to be decided, or if that's part of what would be an argument. Would I'm okay to set a brief hearing out just a little ways and let you discuss it, and then if you can't resolve whether that should be something that Ms. Bong should have to address or not in her closing, we could get there.
So, Your Honor, would you say that we can just put in our stipulation that we will not need to address whatever we agree upon with regards to defenses raised? So we can agree.
That would be an
to
option
stipulate-
if you wanted
Okay.
to get the agreement of the state not to use a particular defense. But in terms of your motion to strike, I probably do need to at least address that and deny it if it's unnecessary or grant it if it's correct. But I think probably I should give the state and you a chance to figure out what each of you mean when you're making that argument, if you intend to make that argument. And we should probably set a brief hearing out a little ways to check up on whether we need to have that argued separately from closing. Would that make sense?
Yes.
Yeah, and Your Honor, I do think that some of them are important because, I'm just looking through these here. Like one of our, defenses is that this is the wrong forum and standing, having to do with federal issues and such. So, Bong case we have going and that sort of thing. It's just, but maybe I don't know what you want to do. You got another hearing.
Yeah, let's set. We'll to understand to what we straighten it out then. But I want to give you enough time, and I realize she's having surgery too. So I'm.
And I will say, Your Honor, I don't think these defenses are something we can agree to because they're kind of. I don't think that. I just think we can. So maybe we should pick a date, even if it's after Ms. Bong's surgery.
Yep.
Just to get it on
No
your
problem.
calendar. I know how tricky that is.
Well, our calendar usually isn't that bad, but
No.
I understand an attorney's calendar can be a mess. So what I'm looking at would be like April 19.
That should be okay. What time did you have?
I was looking at 9 to 9:30.
Well, that works for me.
I have no
Ms. Bong?
objections to that as well.
Okay.
Pending.
And so
It depends on how my surgery goes. So there might be
Okay.
something that crops up between now and then that I may have to raise to the court and Ms. White at a later time.
that's fine. And
Oh,
given
sure,
that
I'm
it's
sure
a
we
half
could
hour
move it
hearing,
if something happens.
yeah, we would move it. It's fine. We might need you to appear remotely like you're doing now or whatever, but I'm pretty sure we can handle it because a half hour slot isn't that hard to find. So let's go ahead and say, at least at this point, April 19th, to address that motion to strike and see what, if anything, needs to be struck, and we will go from there.
And Your Honor, I would request and hope that it could be by video anyway, since we're both up here in the
Yes,
greater
and
Salem.
since I'm not expecting people to present sworn testimony, remote appearance is perfectly fine.
Okay,
So,
excellent.
any and all. Okay. So it sounds like we have a date, April 19th at 9 a.m. for a subsequent follow-up on the motion to strike. Otherwise, we have deadlines for submitting argument, and we will see you on the 19th or hear from you anyway.
Yeah, will your assistant be sending us a new video connection, or do we use this one? What do you prefer?
It'll be this one. Should be
Okay.
the same one.
Well, excellent.
Okay. Thank you, everybody.
Thank you, Your
very
Honor.
much.
All right.